Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Ms. Brady, is this an appropriate time for me to give your client the courteous advisement with respect to phase 2 of the sentencing hearing?
Yes.
Mr. Holmes, I need to speak to you directly at this time. If there's anything that I say to you that you do not understand or do not hear clearly, would you please let me know?
Yes.
And can you hear me clearly so far?
Yes.
I need to tell you that you have a right to testify in phase 2 of the sentencing hearing. If you want to testify in phase 2 of the sentencing hearing, which is the phase that we're in right now, no one can prevent you from doing so. You may take the witness stand and testify in phase 2 of the sentencing hearing, even if it is contrary to the advice of your attorneys. And you're represented in this case, as you know, by Mr. King, Ms. Brady, Ms. Nelson, Ms. Spengler, and Ms. Higgs. All 5 are skilled attorneys, and it's a good idea to talk to them about this, but in the end, you have to make that decision, and you may take the witness stand and testify even if it is contrary to the advice that your attorneys give you. If you were to testify in phase 2 of the sentencing hearing, then the district attorney would be allowed to cross-examine you. If you've been convicted of any felonies, the district attorney would be entitled to ask you about those convictions and thereby disclose those convictions to the jury. If any prior felony convictions are disclosed to the jury, I will instruct the jury that it can consider them only as they bear upon the issue of your credibility. I would instruct the jury that it cannot consider those felony convictions for any other purpose. Now, in this case, I've given you this particular advisement twice, once at the end of the trial and the second time at the end of phase 1 of the sentencing hearing. Both times I asked the prosecution if they were aware of any felony convictions in your past, and both times the prosecution represented that they are not aware that you have any felony convictions, and I'm going to ask them to confirm that at this time. Ms. Pearson?
Your Honor, we are not aware of any felony convictions.
Did you hear that, sir?
Yes.
As you know, Mr. Holmes, in this case, jurors are permitted to submit written questions that they would like to have asked of witnesses. The same rules of law, including the same rules of evidence that apply to attorney questions, also apply to juror questions. The court will not permit improper juror questions to be asked of a witness. If you decide to testify in phase 2 of the sentencing hearing, and if the jury submits one or more questions that the court determines are legally proper to be asked, you will be asked those questions. And you've seen throughout the proceedings how when a witness testifies here in court live, I have allowed the witness to submit questions to me that they would like me to ask of the witness. And each time, the way the process works is that I ask counsel to approach the bench. At the bench, we have a bench conference outside the presence and the hearing of the jury, and I ask the attorneys if they have any objections. If there are any objections to a question, I rule on the objections. If I find that a question is not legally proper, I do not ask the witness that question. On the other hand, if I find that a question from a juror is legally proper, then I ask the witness that question, and the witness is then given an opportunity to answer the question. And following all of the juror questions that I ask of a witness, and of course those would only be questions that I find are legally proper, I ask each side, starting with the side that called the witness, whether there are any follow-up questions based on the jury's questions. The same process would be followed if you decided to take the witness stand and testify in phase two of the sentencing hearing. I mentioned a moment ago that you have the right to testify in phase two of the sentencing hearing. I need to advise you that you also have a right not to testify in phase two of the sentencing hearing. You are protected by a constitutional provision against self-incrimination. Therefore, you do not have to testify if you do not wish to do so. If you choose not to testify in phase two of the sentencing hearing, then the jury may be instructed about that right and that no negative inference can be drawn from the fact that you chose not to testify. And I would give the jury such an instruction unless your attorneys asked me on your behalf not to do so. I'm going to read to you the specific instruction that I plan to give the jury if you elect not to testify in phase two of the sentencing hearing. And this is an instruction that I would give the jury at your attorney's specific request and a request that has been made on your behalf. The instruction, which was tendered by your attorneys and submitted to the court by your attorneys in conjunction with your attorney's request that I give it to the jurors, is as follows. Every citizen charged with a crime or convicted of murder in the first degree has the constitutional right not to testify. The defendant did not testify during the first trial or during phase one or phase two of the sentencing hearing, as was his right. You shall not draw any negative inference from his choice as to the punishment to be imposed or any other matter. You shall not allow his choice to prejudice him in any way. His decision not to testify cannot be used as a reason to support or impose the death penalty. You must not discuss the defendant's choice not to testify or permit it to enter into your phase two deliberations in any way. Did you hear that instruction?
Yes.
The decision whether or not to testify is a decision that must be made by you and by you alone. It is a personal decision. As I mentioned before, in this case, you've been advised and represented by 5 attorneys. I mentioned the 5 attorneys earlier. Have you discussed with your attorneys whether or not you will testify in phase two of the sentencing hearing?
I have.
And have you had enough time to discuss this matter with your attorneys?
Yes.
Do you need more time to talk to your attorneys about this matter?
No.
Have you made a decision as to whether or not you will testify in phase two of the sentencing hearing?
Yes.
And what is your decision?
I choose not to testify.
Is this a voluntary decision?
Yes.
Is this a decision that was made as a result of pressure, influence, threats, promises, or coercion?
No.
Do you have any questions for me about the advisement that I just provided to you?
No.
Do you understand both your right to testify and your right not to testify in phase two of the sentencing hearing?
Yes.
Is there any other record that the people are asking me to make, Ms. Pearson?
No, Your Honor.
Any other record the defense is asking me to make, Ms. Brady?
Sir.
All right, based on my discussion with Mr. Holmes, I find that his decision to not testify in the phase two of the sentencing hearing is one that has been made knowingly, voluntarily, and intelligently. And that conclusion on my part is based not only on the contents of his responses to my questions, but also my observations of him here in court. Is it okay with you, Ms. Brady, if I proceed to advise your client about his right to make an allocution statement?
Yes.
Okay. Mr. Holmes, I need to talk to you now about your right to make an allocution statement in phase two of the sentencing hearing. Can you hear me still?
Yes.
And are you understanding me so far?
Yes.
If at any point you don't understand something I say or you can't hear me clearly, would you please let me know that?
Yes.
Do you understand that you have the right to allocution?
Yes.
And do you know what that means?
Yes.
And do you know the difference between your right to allocution and your right to testify or to not testify? Do you know the difference?
Yes.
Do you understand that if you make a statement, an allocution statement in phase 2 of the sentencing hearing, you will not be under oath? Do you understand that if you make an allocution statement in phase 2 of the sentencing hearing, you will not be cross-examined?
Yes.
Do you understand that if you want to make an allocution statement in phase 2 of the sentencing hearing, no one can prevent you from doing so?
Yes.
Do you understand that you do not have to make an allocution statement and no one can require that you make an allocution statement in phase 2 of the sentencing hearing?
Yes.
Do you understand that if you decide not to make an allocution statement in phase 2 of the sentencing hearing, the jury will not be advised in any way that you have decided not to make an allocution statement to them in phase 2 of the sentencing hearing?
Yes.
Have you consulted with your attorneys concerning this issue?
Yes.
Are you satisfied with the advice of your attorneys concerning this particular issue?
Yes.
Do you desire more time to discuss this issue with your attorneys?
No.
Whether or not you give an allocution statement is your personal choice. Although you may have consulted with your attorneys and they may have given you advice on this issue, do you understand that whether or not you give an allocution statement in phase 2 of the sentencing hearing is your choice and not the choice of your attorneys?
Yes.
Whatever your decision is it your free and voluntary choice and your own personal decision? Do you have any questions for the court before I ask you about your decision?
No.
And have you decided whether you are going to make an allocution statement in phase 2 of the sentencing hearing?
Yes.
And what is your decision?
No.
So you will not make a statement, is that correct?
Yes.
And do you understand that I will give you this advisement again if there is a phase 3? If there's not a phase 3, obviously it's a moot issue, but if there is a phase 3, I'll give you the same advisement again at that time, and you'll have an opportunity at that time to make an allocution statement. Do you understand that?
Yes.
Okay. Is your decision not to make an allocution statement in phase 2 of the sentencing hearing a free and voluntary decision?
Yes.
And is it your own personal decision?
Yes.
Any other record that the people are asking me to make with respect to Mr. Holmes's right to make an allocution statement in phase 2 of the sentencing hearing?
No, Your Honor.
Any other record that the defense is asking me to make with respect to this issue?
No.
All right, and based on the record made, I find that this is a knowing, intelligent, and voluntary decision by Mr. Holmes not to make an allocution statement in phase 2 of the sentencing hearing, and that finding is based not only on the content of his answers to my questions, but also based on my observations here in the courtroom. All right, with that then, let's proceed to talk about the instructions.
Your Honor, can I have a second to review the transcript? You may have misspoken on one thing, and I just want to check that.
Yes.
Okay, thank you.
You don't mean the transcript, you mean the real time.
Your Honor, it's possible that you said that witnesses would get to ask him questions instead of jurors. And I don't know how to search this for that, but if that's the case, I just wanted to make sure that was corrected. I'm not saying it is.
Okay. Well, we can just play it safe and I can go back through it. This is with respect to the right to testify or to not testify, correct?
Yes, Your Honor.
All right. Ms. Brady, is it okay with you if I go back over that again?
Yes, sir.
All right. Mr. Holmes, let me come back to the first advisement I gave you a moment ago. Not the last one, but the first one.
Okay.
That's the advisement I gave you with respect to your right to testify and your right not to testify in phase 2 of the sentencing hearing. Do you remember that advisement?
Yes.
I went through the process that we would follow in the event that any juror or jurors submitted questions to me that they would like me to ask of a witness. Do you remember that discussion? Okay. So to the extent that I said that a witness may wish to ask you questions, what I meant was a juror may submit questions for me to ask of a witness, and if you take the witness stand, you would be a witness, and if I found that any questions from a juror was legally proper, I would ask that question of you. Do you understand that?
Understood.
On the other hand, if I found that a question was not legally proper, a question submitted by a juror was not legally proper, then I would not ask you that question if you took the witness stand and decided to testify. Do you understand that?
Yes.
And if I asked you any questions that were submitted by the jury, I would give each side an opportunity to ask follow-up questions, starting with your attorneys. Do you understand that?
Yes.
Mr. Orman, does that clarify it?
I would just ask the court to inquire whether that changes his mind or his decision regarding whether to testify or not.
Does that in any way change your mind about whether you wish to testify or to not testify in phase 2 of the sentencing hearing?
My position remains
Okay, and so your decision is what?
not testify.
Okay, and is that still a voluntary decision?
Yes.
And is that a decision that has been made as a result of pressure or influence or threats or promises or coercion?
No.
And do you need any more time to talk to your attorneys at all about this?
No.
Have you talked to your attorneys about this before?
Yes.
Okay. Any other record, Mr. Orman?
No, Your Honor, thank you for doing that.
All right, thank you. Any other record, Ms. Brady?
No, sir.
Okay, thank you. All right, now let's move on to the instructions.
Your Honor, could I ask the court to talk about two brief scheduling matters really quickly before jury instructions?
Yes, and actually, I'm going to preempt you because I asked a question earlier, and I think your co-counsel said they needed to check with you. So is that one of the issues you want to talk to me about?
Yes, thank you, Your Honor.
All right, go ahead.
Your Honor, I polled the victims briefly, and they requested that I ask the court for 2 hours to get to the courthouse after the verdict. And so the court knows I have victims who live in Canyon City who do actually come up for the verdict announcements, as do I have victims in Fort Collins who'd like to come down from Fort Collins. So I don't know if that's acceptable to the court, but that's their request.
All right, is there any objection, Ms. Brady? No? Okay, that's acceptable. This is not a typical case, and I understand there are a lot of people interested in it, so the request for 2 hours is granted. What else?
Thank you, Your Honor. The other question that people had is, if we get to phase 3, whenever the jury may come back with verdicts for phase 3, for scheduling purposes for victim impact witnesses that the people may have, we were wondering if the court would permit us to start putting on the witnesses the day after the verdicts are announced.
Say that again, I didn't follow that.
Sorry. So if, let's say the jury came back with verdicts on Thursday, if they found that we were to go on to phase 3, would the people be permitted to then start putting on witnesses on Friday instead of, like, let's say they came back Thursday morning? I don't know that I would have witnesses ready for Thursday afternoon. So I'm wondering if we could have until the start of the next day to start putting on our witnesses.
Does the defense have a position, Ms. Brady?
Your Honor, that really makes sense, because I think there will also be the
Right. So I think we can use that time anyway, so that request is granted as well.
Thank you, Your Honor.
Okay, thank you. All right, now let's talk about instructions.
Ask a question. Does the court plan on going until we're done?
Yes. Okay, let's start with the instructions. Yesterday, we went through some of the instructions, and to the extent that anyone wants to make any additional records or objections with respect to the instructions we spoke about yesterday, we can come back to them. But what I would like to do is just go forward. The first thing I want to do is I want to clarify the record that earlier today, Mr. Edwards withdrew the objection that the people made yesterday to some language in the instruction that starts with a mitigating factor is not a justification or excuse for the crime. And my understanding is that Mr. Edwards withdrew the objection to the language that begins in the third sentence of the third full paragraph of the first page of that instruction, and then it ends on the second page, wherever that paragraph ends. He had objected to all of that language yesterday. And so that objection has been withdrawn. Is that correct, Mr. Edwards?
Yes, Your Honor.
All right, thank you, and I appreciate your candor. There was
No,
an,
I'm so sorry to interrupt. I've been shifting around. Can I just ask the court to remind me where that instruction is?
it starts with a mitigating factor is not a justification or excuse for the crime. This is the one where we had a lengthy discussion yesterday about Lockett and McCoy and some of their case law. So there was an additional objection, and McCoy, by the way, has an unusual spelling. I think it's capital M, small c, K-O-Y. So there was an additional objection that Mr. Edwards had made separate and apart from that objection and without waiving that objection, and that is to the first line of page 2 of that instruction. He had suggested that, actually, I think that there was a request by Ms. Nelson and then a request by Mr. Edwards. Ms. Nelson had suggested that the last part of that first line read as follows: cannot and does not limit your individual determination about mitigation. Mr. Edwards had asked that part of that very first part of the second page of the instruction read as follows: cannot and does not limit your deliberations and individual reason moral judgment. What I think makes sense to do is to have it as follows: cannot and does not limit your determinations about mitigation. I think that takes care of the request by Ms. Nelson, and I think it takes care of the concern expressed by Mr. Edwards in terms of the use of the word individual and whether this was an anti-deliberations type of change. So that's how I've decided to change it. With that in mind, let me tell you that I have made all the changes that I indicated yesterday I would make to instruction, the first instruction, the second instruction, the fourth, there were no changes to the third instruction. The fourth instruction is the one we were just talking about, and I have made the change that I just mentioned, as well as the other change that I said yesterday that I would make. And then one additional, actually yesterday I said I would make two changes on this instruction. One was with respect to the first paragraph at Ms. Nelson's request in the second sentence to add or as diminishing the appropriateness of a death sentence. That change has been made. The other one was at Mr. Edwards' request in the last paragraph of the last page, the second line, to take out the words as aggravation or right before the words as an aggravating factor. So I made that change as well. And then I have made the change also that I just talked about earlier today in terms of the first line of the second page will not read cannot and does not limit your determinations about mitigation. The next instruction is the fifth instruction. I made the changes that I said yesterday that I would make, including listing the aggravating factors that were proven by the prosecution in phase 1. And what I've done is I have listed them, instead of listing them as alleged aggravating factors, to keep it simple, I've listed them as first aggravating factor proven, and then rather than put the title of it or any type of heading of it, I put the actual language of the elements. For example, that the defendant knowingly, and then it goes from there, whatever was proven with respect to each aggravating factor. And I've listed the 4. I have not done it as elements. I've done them as sentences, but I've actually included all the language of each aggravating factor, which is, I think, the best way to do it. The next instruction, I have made the changes that I said yes. Actually, there were no changes in that instruction. on the seventh instruction, and we'll come back, because I know we didn't talk about some of these instructions, so we'll come back to them in a moment, but on the seventh instruction, the one that starts with, you must treat the defendant as a uniquely individual human being, I have made two changes at Mr. Edwards' request. It now reads, further, in reaching your decisions in phase 2 of the sentencing hearing, you must not be influenced by prejudice or bias of any sort for or against the defendant, and you must not consider any public opinion or community sentiment for or against them. So I have added for or twice in that sentence, and I think that makes it neutral. I don't have any changes on the next instruction or the next one after that.
Judge, could you read the first several words? Because I think I've got my instructions confused here.
Okay, the next one is you may consider mercy for the defendant during phase 2.
That's fine, thank you, Judge.
The next one is, as to each count of murder in the first degree, the sentencing hearing will only continue to phase 3, and then it goes from there. The next instruction is, neither party has the burden to prove anything in phase 2 of the sentencing hearing. The next instruction is the reasonable doubt instruction, and I have decided to leave it in, and I'll give Ms. Nelson an opportunity to make a fuller record if she wishes to. But I think I have to define reasonable doubt. I know the point that she made yesterday, but I think that point is addressed in the instruction that precedes that one, that tells the jury this is not being given to you as a term that applies to a burden of proof. Reasonable doubt is referring here to the moral certainty that a juror has to have before the juror may conclude that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1. But in the end, I still have to give the jury a definition of reasonable doubt. So it's in. The next one starts out with, you are instructed that the fact that the prosecution seeks the death penalty in this case is entitled to no weight, and then it goes from there. There are no changes that I have made to that one. The next one starts with, in reaching your phase 2 sentencing verdicts, you may consider all of the evidence admitted during the proceedings. I have not made any changes to that one. The next one the next one is, the court reminds you that a fact may be proven by either direct or circumstantial evidence. I have not made any changes to that one. The next one starts with, the court reminds you that the number of witnesses testifying for or against a certain fact, and it goes from there. I have not changed that one. The next one starts with, the court reminds you that you are the sole judges of the credibility of each witness, and it goes from there. I have not changed that one. The next one is, the court reminds you that you're not bound by the testimony of witnesses who testified as experts. I have not changed that one. The next one is, every citizen charged with a crime or convicted of murder in the first degree has a constitutional right not to testify. I have not changed that one. The next one is, you were permitted to submit written questions to witnesses during the trial, and it goes from there. I have not changed that one. The next one starts with, you have been allowed to take notes. I have not changed that one. The next one is, once you begin your deliberations, if you have a question, I have not changed that one. The next one is one that starts with, there is no requirement that you articulate, explain, or justify to your fellow jurors why you reached a particular determination, whether with respect to the existence of mitigating factors, the weight assigned to each aggravating factor and each mitigating factor, or the weighing process. Mr. Edwards objected to this language, and I went back and looked at the tendered instructions from the people, and they have one that's very similar to this one. It says, while there is no requirement that you understand or articulate to anyone why your individual reasoned moral judgment leads you to any particular result, you must each be given a complete opportunity to speak during the deliberative process if you wish to speak. And then it goes from there. That's part of the one that was tendered by the people. What I did do on this instruction is I deleted the sentence that follows in my instruction, the one that started out with, nor are your decisions required to reflect the determinations, opinions, feelings, or thoughts of other jurors. And the reason I took that out is because I think that's confusing, and I think it could be misinterpreted. In the end, if the jury reaches a verdict, the verdict has to be unanimous. So I took that sentence out, and we can come back to it if the parties want to argue further about that. Those are all the changes that I have made from yesterday until today. There's one last instruction that follows the one I just talked about, and I have not made any changes to that instruction. So with that being said, Mr. Edwards, where do you want to start? Do you have any other objections that you haven't made and that I haven't addressed?
Judge, I'm not sure that this is so much as an objection as pointing something out. On the direct and circumstantial evidence instruction,
Yes.
it says, reminds you that a fact may be proven. Well, here they're instructed that mitigation doesn't have to be proven or disproven. So I don't know if the court wants to do something about that language or not. Frankly, for me, it's a little issue, not a big issue.
Ms. Nelson, what are your thoughts? It's given, of course, because the jury can consider the testimony from the trial, and so it would apply to that extent. In fact, it would apply to the testimony, to some extent, to the testimony presented in Phase 2, although I understand your point that the ultimate determination isn't solely a factual one, and I don't want to mislead the jury.
Your Honor, I think the position that we took with respect to this instruction is that it's not necessary or appropriate in Phase 2, so we don't have an objection to the court taking it out.
Mr. Edwards, are you okay with me taking it out?
That's fine, Judge.
Okay, I'll take it out. The reality is that the jury has seen this instruction twice now, so they get what direct evidence and circumstantial evidence is, and I think if we leave it in, it runs the risk of confusing them more than anything. What else, Mr. Edwards?
Your Honor, the last one that I have is the one that the court pointed out that starts, there's no requirement that you articulate, explain, or justify.
Okay, let me get to it. Yes, and like I said, I took some of the language from the defense's instruction and some of it from yours, but go ahead.
I understand that, Judge, and we're taking a little bit different position on this one, that there's no requirement that you articulate, explain, or justify to your fellow jurors why you reached a particular determination. Well, this has to be based upon reasoned moral judgment, and I want to stress reasoned, so that you can't just in your mind think maybe there's mitigation, but I don't have to even articulate it to myself as a juror. It's our position that it's arbitrary and also non-reviewable, and we would, reviewability is very important because it goes to reliability. And in 18.1.3, 1201.6, talking about the Supreme Court review, the statute reads, the Supreme Court shall review the propriety of the sentence having regard to the nature of the offense, the character and record of the offender, the public interest, and the manner in which the sentence was imposed, including the sufficiency and accuracy of the information on which it was based. Well, if you look at that, the Supreme Court needs to look at the evidence and determine whether or not it was sufficient and accurate. And if jurors are making individual determinations of what they believe is mitigation on top of that, they don't even have to articulate it to themselves, let alone fellow jurors. It makes the process arbitrary.
Let me make sure I understand your objection. Your objection is not so much to the language at the beginning of the sentence. There's no requirement that you articulate, explain, or justify to your fellow jurors. It seems like your objection is aimed more at the second part of the sentence, which would start with why you reached a particular determination, whether with respect to the existence of mitigating factors, the weight assigned to each aggravating factor and each mitigating factor, or the weighing process. You're saying that you're sticking with the tendered instruction, your tendered instruction, which reads, there's no requirement that you articulate or you understand or articulate to anyone why your individual reasoned moral judgment leads you to any particular result. Is that right?
Right, and that's a little bit different than what this instruction says. The problem I find with this instruction, Judge, is it says there's no requirement that you articulate. Well, they don't have to explain or justify. I understand that. That's individual reason, moral judgment. But they have to be able to articulate it. They have to be able to say this is what it is, because the Supreme Court has to be able to review it.
So you're not, you're taking an issue with the word articulate, but you're also taking an issue with the rest of it, or no, just the word articulate? In other words,
Right.
is your objection just limited to the word articulate, or are you also asking me to change the second part of that sentence that talks about any particular determination and to limit it only to individual reason, moral judgment?
Your Honor, yes, it needs to be based on individual reason, moral judgment. What I'm saying is the juror has to be able to articulate it.
Okay,
Be able to articulate to themselves, articulate to other jurors, so that it's reviewable by the Supreme Court.
so if I take out the word articulate, that takes care of your concern?
Yes.
All right, what's the defense's position?
Your Honor, this argument that individual jurors have to articulate their reasoning so that the Supreme Court can review it is a farce. There is no requirement, once a verdict is given, that any particular juror in either the merits, quite frankly, or the penalty phase of a capital case, that any particular juror give their reasoning for their verdict. The reviewability by the appellate courts and the Supreme Courts is based on the information in the record. The jurors are never asked, well, what evidence did you use, or why did you come to that conclusion? That is simply not part of reviewability. We believe that jurors are not necessarily required to articulate, put into words, why they are coming to their conclusions. We see no support from the prosecution of their position that jurors must be able to somehow articulate it. And so we would object to removing that language. We would object based on Mr. Holmes' right to due process, to a fair trial, to a fair and reliable sentencing hearing, to a fair and impartial jury under the 5th, 6th, 8th, and 14th Amendments, and the 6th, yeah, I got the 6th, of the United States Constitution, Article 2, Section 1620, Colorado, 1620, 25, and 23. Thank you.
Judge?
Hold on. I frankly did not find Mr. Edwards' argument particularly persuasive, but my concern with this sentence is that it contradicts what follows, which is telling the jury that he has a duty to deliberate. On the one hand, I'm saying, hey, jurors, you don't have to articulate or state why or any determination that you make in deliberations. On the other hand, I'm telling them, hey, jurors, you have a duty to deliberate. And I remember when I drafted this, that was a concern for me because it seems to me there's a conflict between those two concepts. I think we get the same, or I think we get the effect or the intended message if we say, hey, you don't have to justify or explain yourself, but you have to deliberate. I think that's less risky in terms of causing confusion or creating a conflicting instruction than if you say you don't even have to articulate it, you don't even have to say it. So I'll take out the word articulate, but I will leave explain or justify, and then I will leave, for now anyway, the duty to deliberate until I give Ms. Nelson a chance to be heard or Ms. Higgs a chance to be heard on the rest of this. All right, Mr. Edwards, what else from you?
That's all I have to.
All right, let's go to the defense then. Ms. Nelson? And Ms. Nelson, just so that I don't forget, do you mind starting with the instruction that Mr. Edwards tendered last night? Have you reviewed it? The one that says, while you may consider compassion for the defendant based upon the evidence, any compassion for any other person, including the defendant's family, friends, and other people, is not mitigation and should be excluded from your consideration.
I have a copy of that. I made some notes on it, but I don't have it in front of me. May I take just a moment to look for it.
As long as you don't let me forget it, you can proceed with the rest of the instructions. I just don't want to forget it.
I'll tell you that we do object to it,
Okay.
but I would like it in front of me.
All right.
This is, actually, would it be possible to get some batteries for the body mic? Yeah. Or maybe I could just use, that would be great. Thank you, Mr. Orman.
Thank you. And while she's doing that, Mr. Edwards, California versus Brown doesn't have that specific language, neither does Lockett versus Ohio. Those are the two cases that you've cited in support of that tendered instruction that I just read.
Lockett talks about what is appropriate mitigation, and California versus Brown talks about the anti-sympathy instruction, that is mere sympathy cannot be used, or the emotional response just to the defendant that's unattached to evidence cannot be used. Well, if it's constitutional not to use sympathy, mere sympathy, that's unattached to the defendant, as mitigation, then it is also inappropriate for the jurors to say, boy, I really feel sorry for the mother, and because I feel sorry for the mother and her situation, therefore I'm giving a life sentence. That is not mitigation. It has to relate to the defendant.
Well, I don't disagree with you. I just don't know that an instruction from the court is necessary on that point. Ms. Nelson?
I agree with the court. I think that this instruction runs the risk, well, it really does, it unconstitutionally limits mitigation. The word compassion is, I don't find any support in the cases cited by the prosecution for the use of that term, nor the instruction in general. Mitigation and this assessment that's required during phase 2, the individual reason moral determination by jurors, requires a moral evaluation of Mr. Holmes lives or dies, and that encompasses the testimony of the lives that he's touched and his friends and his family members. And my concern is that the instruction is tantamount to telling the jury that they can't find mitigation testimony emotionally compelling. And his love for his family and his family's love for him is relevant mitigation, I think, clearly under United States Supreme Court case law. So we would object to that under Mr. Holmes's constitutional rights, under the 5th, 6th, 8th, and 14th Amendments, United States Constitution, as well as Colorado Constitution, Article 2, Section 16, 20, 23, and 25. And before I forget, I'd also ask that the prosecution file this instruction with the clerk just so that it's made part of the official record in the case. I just don't want it to get lost, especially in the event the court's considering giving it at all.
I read it into the record. I'm not giving it. I'm rejecting it, and I think that's sufficient record. If the people want to file it, they can. But I don't think it's necessary. If the attorneys want to address that in closing arguments, I think they can. But I don't think it's an instruction that is necessary. I don't think this jury is going to be confused or thinking that mitigation includes mitigation that relates to relatives or family members or sympathy for family members. And again, the attorneys can address that, but I just don't think it's needed. So it's rejected. All right, Ms. Nelson, let's start with you. We talked about the first four instructions actually yesterday.
We did.
So I think we were up to number 5, which is when you're retired to deliberate.
Actually, I think we talked about that one too.
Yeah, we did talk about that one
Yeah.
too, sorry, all right. And then the next one is, the sixth one, number 6 would be based upon your earlier verdicts.
That,
And actually, we talked about that one as well, I think, to some extent, right? Because I remember you saying that you objected to the merger issue and you incorporated by reference your prior record, and I incorporated by reference my prior ruling on that.
that comes up a few times in these instructions. I don't recall whether we specifically addressed that, but I do continue to maintain my prior objections based on the merger arguments.
Anything else with respect to this particular instruction?
No.
Okay.
Thank you.
The next one is you must treat the defendant as a uniquely individual human being. Any objection?
I do object to the changes that the court made at the prosecution's request. I don't really know what prejudice or bias for a defendant even means in this context, but to the extent that it means feelings of mercy or compassion for him or sympathy for him, the law says that that's an appropriate influence to have in reaching their determined moral, individual reasoned moral judgment. So I would object to the changes that the court made.
May I address the court?
Yes.
Your Honor, where this instruction came from, it originally came from the Owens case. And Mr. Owens was black. And that's why a prejudice instruction was entered at all. And it was against the defendant because the argument was that they should be able to consider the fact that he was black and he had a deprived childhood and those types of things because of his race should be able to be used. Carried over into the Ray case, Mr. Ray was black, carried over into the Montour case, and Montour was Hispanic and American Indian. So this instruction actually came from cases where the defendant was a minority. I'm not sure it's even an issue in this case or whether it should be given. But if it's given, we believe that the court's modifications are appropriate.
The other way to change it would be to say, instead of saying by prejudice or bias of any sort for or against the defendant, you could say influenced by prejudice or bias of any sort against the defendant or the prosecution.
That's fine with people.
Ms. Nelson, which do you prefer?
I would object to either or, Your Honor. I maintain my position that it's correct the way that it was submitted and the way that the court originally issued it. I don't understand the concept of prejudice or bias against the prosecution doesn't really make a whole lot of sense in this context. The prosecution is just sort of this nebulous, they represent the people. And what we're talking about here is an individual's life, and it's his constitutional rights and the concern. And I don't know what relevance the Owens, the Ray, the Montour case has to these proceedings. This is an instruction that was tendered in this case because we think it's relevant and important in this case. And the concern here, obviously this is a very high profile case, and there's been a lot of public opinion and community sentiment. So this doesn't have to do with race, it has to do with the nature of the case.
Well, but you could see a situation where someone is biased against the prosecution because they're upset that they've spent money on this case or that they are seeking a death penalty in this case or something along those lines. Jurors are not allowed to be biased or prejudiced against either party. So I understand the objection, but it is overruled, and I'll give you, without waiving your objection, I'll do whichever of the two you prefer. So whichever of the two is least objectionable to you, I will go with that one.
Can we think about that for a moment and come back to it at the end?
Okay. All right, what else? The next one starts with, you may consider mercy for the defendant during phase 2 of the sentencing hearing, and then it says your exercise of mercy must be based upon the evidence presented during the proceedings. You object to this one?
We do. We continue to object to instructing the jury that their exercise of mercy has to be based upon the evidence, and I understand the court's prior rulings on this issue. I would like to just supplement my record on this issue with a few additional citations to the court.
I will let you do that. Let me just state that I'm not necessarily tied to this language, but the concept has to be, in my view, explained to the jury. I don't think the jury can just be told that they can exercise mercy for the defendant in a vacuum. So in terms of whether we say your exercise of mercy must be based upon the evidence, I'm not tied down to based upon that terminology, although I think that's the most accurate and I think the least, the most clear way of doing it, the least confusing way of doing it. If you have a suggestion, I will entertain it, but I have to tell the jury something to make sure they understand the law correctly. It would be, in my view, incorrect to say you may consider mercy for the defendant during phase 2 of the sentencing hearing and leave it at that. Okay, with that, you may supplement your record with additional citations.
I would say at the court to Gregg versus Georgia, 428 U.S. 153 199 from 1976. People versus Davis, 794 P. Second, 159, 193, Colorado Supreme Court, 1990, which has a discussion of mercy, several points and places in that case. It suggests that it was appropriate for the defense counsel to ask the jury for mercy in closing argument, and that the jury was not misled by instructions to believe that it couldn't consider mercy. As well as a Georgia case, Barnes versus State, Barnes, 496 Southeast 2nd, 674 from 1998, Georgia case from 1998. And that case expressly states that mercy alone by itself is a valid reason for the jury to decline to impose a death sentence.
And I read that portion of the Davis case last night, as it turns out, but I don't think the court was saying in an instruction it's appropriate for the jury to be told that they can exercise mercy in a vacuum. Otherwise, I keep coming back to this. I don't know why we took 2 months selecting a jury. I mean, if jurors are allowed to come in here and without regard to the evidence presented in the trial, they can make decisions completely independent of what was presented in the courtroom, then I'm not sure why we took so long selecting a jury. And I think the questions we should have been asking in jury selection should have been different if that's the case. So, all right, let's move on. The next one it starts with, as to each count of murder in the first degree, the sentencing hearing will only continue to phase 3 if the jury is unanimously convinced beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing. Any objection to this one, Ms. Nelson?
I just have some suggestions regarding just rephrasing things slightly.
Okay.
And if I can make sense of my own notes here, I think, let's see here. So the beginning of the second sentence regarding a count of murder in the first degree, I would propose just omitting that phrase. Again, and this kind of goes back to what we were talking about yesterday. Yes, they have to engage in the weighing process individually for each count, or our position is each conviction. But I don't think we have to say that every time. And you said it in the first sentence, as to each count of murder in the first degree.
I agree with you. Do you agree, Mr. Edwards?
That's fine, Judge.
Okay.
So it's stricken to the comma?
Yeah, so it'll start out with, if every juror is individually convinced.
Okay.
And actually, now that I'm looking at my my notes, I think I would propose rephrasing the entire sentence to read, the sentencing hearing will only continue to phase 3 on a particular count if every juror is individually convinced beyond a reasonable doubt that the mitigating factors found to exist do not outweigh the proven aggravating factors.
We don't have a position on that, John.
Okay, I'm fine with that. Hold on.
It's just a way to communicate it a little more clearly, because it gets confusing with that Tennyson language sometimes.
All right, the sentencing hearing will only continue to phase 3 of the sentence.
On a particular count.
Okay, on a particular count. If every juror is individually convinced beyond a reasonable doubt that the mitigating factors found to exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing, period. Correct?
Correct, or I think the court could just say the proven aggravating factors.
Okay, just end after aggravating factors?
Proven aggravating factors.
Okay, I'll make that change too. All right, proven aggravating factors.
And then I think the next sentence that says regarding a count of murder in the first degree, I think it should say if any juror is not so convinced rather than every juror, because that implies, it's confusing, it implies unanimity is required. And I would also propose adding, so it would read, if any juror is not so convinced or has a reasonable doubt about whether the mitigation does not outweigh the aggravation, then the sentencing hearing will end.
Do the people have a position, Mr. Edwards?
We don't especially object to that, but we would suggest if any or every juror is not convinced. That way they can be unanimous for life, or they can be individually for life.
I guess my concern with that, Your Honor, is that we just don't want to imply in any way that a non-unanimous verdict is
How about,
not
how
a
about if
valid
I,
verdict.
sorry, I'm sorry I interrupted you. You said to imply any way that a unanimous verdict is,
Oh, I just don't think that we need to be conveying to them that they need to be working towards a unanimous life verdict. So I think the most legally accurate thing to say is just any juror.
how about if I said each, regarding a count of murder in the first degree, if each juror is not so convinced, then the sentencing hearing will end with respect to that count, and it goes from that.
I think that's the same problem as every, because it says if you're saying if each juror is not so convinced, that means that each juror has to reach the same conclusion in order for the sentencing hearing to stop. So I think it has to say any.
All right, I'll change it to any at the defense's request. So it'll say if any juror is not so convinced, then the sentencing hearing will end with respect to that count, and then it goes from there.
And
I don't think adding the other language about, or if a juror has reasonable doubt, I mean, I think this covers it, right? If any juror is not so convinced, by saying so convinced, it's referring to beyond a reasonable doubt in the sentence before.
we maintain our position that we'd like the court to include that language just because it can get a little bit confusing, but
So you want me to say if any juror has a reasonable doubt?
I think, well, I'm satisfied with any, but we would ask the court to say if any juror is not so convinced or has a reasonable doubt, maybe the court could just say, or has a reasonable doubt about the outcome of the weighing process. Maybe that's a simpler way of saying it. Then the sentencing hearing will end.
I think that's confusing. I think that we should either stick with if any juror is not so convinced, or we should go with something else. But I think if you try to do two, then it seems to me makes it confusing.
Then let's just stick with if any juror is not so convinced.
All right, okay, we'll stick with that. What else?
That's it for that instruction.
Okay, great. The next instruction starts out with neither party has the burden to prove anything in phase 2 of the sentencing hearing.
Can I just have one moment? On this one, we maintain the objection that we made in motion D-146 that the prosecution should bear the burden of proof at phases 2 and 3. But other than that, and while maintaining that objection, we don't have anything additional on this one.
Okay, I incorporate by reference my rulings on those objections. The case law is clear that there's no burden of proof on either side in phase 2 or phase 3. And I think it's Dunlap that talks about that.
And the next instruction, the reasonable doubt instruction, I stand by the record that I made yesterday.
And Mr. Edwards, you're standing by your record yesterday on reasonable doubt?
Yes, Your Honor.
Okay. I think I have to give that definition for the reasons that I stated. I think we're using the term. I think I have to define it for the jury. So what about the next one? You were instructed that the fact that the prosecution seeks the death penalty in this case is entitled to no weight, and then it goes on from there.
Nothing on that one.
Okay, the next one is, in reaching your phase 2 sentencing verdicts, you may consider all of the evidence admitted during the proceedings, and it goes from there. Any objections to this one?
We continue to maintain our objection and argument that we made previously about the phrasing existence or absence of any mitigating factor, as well as incorporate by reference all of the constitutional objections that we made in the litigation leading up to this, the trial regarding the constitutionality of the statute. But aside from that, I did have a suggestion in terms of rephrasing or rewording just one sentence. So Second sentence, however, the evidence admitted during phase 2 of the sentencing hearing for the limited purpose of determining the existence or absence of any mitigating factor may only be considered for that limiting purpose, period. Such evidence may not be considered as evidence of aggravation or for any other purpose, and then just take out that next sentence. So it's combining the sentence that follows into that sentence, and then starting a new sentence about what the evidence may not be considered for. If that makes sense.
Okay, so they would read as follows. However, the evidence admitted during phase 2 of the sentencing hearing for the limited purpose of determining the existence or absence of any mitigating factor may only be considered for that limited purpose. Such evidence may not be considered as evidence of aggravation or for any other purpose. Right?
Yes.
Mr. Edwards, any objection?
No, Your Honor.
All right, I'll make those changes. In terms of the substantive objection, I stand by all previous rulings and I incorporate by reference all those rulings. Whether I've made the rulings before the trial or during the trial, and actually I think I've made rulings both before trial and during the trial. The statute is clear as to the limited purpose for which evidence that was admitted during the trial may be allowed in phase 2 of the sentencing hearing. And what the statute says is that it may be admitted for the limited purpose of determining the existence or absence of any mitigating factor. So I'm using exactly the language from the statute, and I stand by my finding that the statute is not unconstitutional, a finding that I made before the trial started. The next instruction starts with the court reminds you that a fact may be proven. Oh, that one's coming out, so never mind.
And then I don't have anything on the next two.
Okay,
So the next one, just on the expert witness instruction, Your Honor.
yes?
I was wondering if the court would consider adding something, I know we added something to the expert witness instruction in phase 1, and I would propose just adding, because there was so much expert witness testimony about the issue of mental health, that you may not consider, you're reminded, maybe or something like that, you're reminded that you may not consider the testimony of any expert who testified on the issues raised by the defendant's plea of not guilty by reason of insanity as evidence of aggravation or a reason to impose the death penalty.
Mr. Edwards?
Judge, we don't have any objection to that as long as language, something like the jurors may consider it as rebuttal to mitigation. Otherwise, it looks like the jurors can't consider it at all. And they can consider it as rebuttal to mitigation. They just can't consider it as evidence of aggravation or a reason to impose the death penalty.
Told that they can consider it as rebuttal to mitigation and an instruction, I mean, yes. in one of the instruction we just discussed a few moments ago. And we continue to maintain our objection that, and I would object to the language rebuttal to mitigation. I think we object to the language altogether about proving the existence or absence of any mitigating factor, but if the court's going to stick to that language, then it should stick to that language.
I think what I can do is add the following. You may not consider the testimony of any expert who testified about the issues raised by the defendant's plea of not guilty by reason of insanity as evidence of aggravation. You may only consider such testimony for the limited purpose of determining the existence or absence of any mitigating factor. And maybe I'll start out with the court reminds you or something like that. Is that all right with the parties?
It's fine with people.
Ms. Nelson? Yes. And to avoid repetition, what I'll do is I'll start the first paragraph of the instruction as follows. As the court has mentioned before, comma, you're not bound by the testimony of witnesses who testified as experts, and it goes from there. And then I'll add, as a separate paragraph, the language that I just read a moment ago. And then the last line will be the way you give the testimony is entirely your decision. Actually, you know what, I'll leave that line right after the first paragraph, and then I'll add a paragraph. The paragraph that I just talked about with the parties will be at the end of that.
Your Honor, the more we're thinking about it, we think we may just be more comfortable just leaving the instruction alone. Yeah.
Okay, that's fine. We'll leave it alone.
Unless, perhaps the solution would be to move the order of the instructions so that the limiting instruction comes right before or after the expert instruction. I don't know if that makes sense.
Yeah, I can
in terms
do
of the
that.
flow or
Do
something.
the people have any objection to that?
I'm not sure what,
She's saying move the order of the limiting instruction to right after the expert instruction that we just talked about, right?
Yeah.
that's fine, Judge.
Okay, I'll do that.
And the next instruction, the court's ready.
Yes.
We think citizen should be changed to person.
Okay, I did it the way you tendered it, but.
I realize that.
Okay, every person?
Yes, we just
Alright.
caught that. Nothing on the next one about questions or note-taking.
Questions during deliberations.
Nothing on that one.
And then we get to the one that we were just talking about, or that we've addressed. Is there anything else you want to make a record about, the one that starts with there's no requirement that you, and then it goes from there?
Can I have just a moment on that? I know that the court took that second sentence out. We object to that. We think that that sentence is an accurate statement of the law and not confusing. But understanding the court has determined that it wants to take it out, we were just thinking about some alternate language, and if I could just have just a moment.
And for the record, the language was, nor are your decisions required to reflect the determinations, opinions, feelings, or thoughts of other jurors. And again, my concern is that I think that can be interpreted in a way that is inaccurate.
We would propose, nor are you required to agree with the determinations, opinions, feelings, or thoughts of other jurors.
Mr. Edwards?
We have no objection to that, Judge.
Okay, I will add that sentence.
We would request the court just take out the second sentence in that second paragraph. After all, these are the jury's phase 2 deliberations. It doesn't seem to add anything potentially confusing to the jury, since the phase 2 deliberations are different than the phase 1 deliberations and the merits deliberations and all of that. So I think the first sentence gets at what the court's getting at.
I almost took that out for that reason. Mr. Edwards, do you have any objection? I think the point is made with the rest of the paragraph.
No objection, Judge.
All right, I'll take that out.
Moment.
Yep. That takes us to the last instruction, I believe.
On the last instruction,
Do you want to make this, I think this instruction might have the same issue that you pointed out in an earlier one, Ms. Nelson,
same issue, yes, same issue, maintain our objection based on the merger argument.
right? And same ruling.
And then I think the other, I did have some suggestions on wording. And I
Okay.
think that the basis for my suggestions is that this instruction is really geared at telling the jurors how to fill out. The purpose of this instruction is to tell the jurors how to complete the verdict form, not really how to deliberate or anything like that. And so I would propose, let's see here. So the sentence that starts out, you must make 24 separate determinations.
Yes.
Right now it says you must determine whether every juror is convinced beyond a reasonable doubt, et cetera, et cetera. And I would,
It says as to each count,
yeah,
you must determine whether every juror is convinced beyond a reasonable doubt, and it goes from there.
and I would propose that it state, as to each count, you must indicate on the verdict form whether or not every juror is convinced beyond a reasonable doubt. And I think that language reflects the way that the court has laid out the verdict form, which is like a yes or a no. And so that's what they have to do on the verdict form, is they have to indicate on the verdict form whether or not every juror is convinced beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing.
Mr. Edwards?
No objection to that, Judge.
All right, so I'll change determine for indicate, and what else?
Indicate whether or not.
Whether or not. Yeah, I've never been a fan of or not, because I think whether implies or not, but I'll add it because you're requesting it. You must indicate whether or not every juror is convinced beyond a reasonable doubt, and then it goes from there, right?
Yes, or you could say you must answer the following question, yes or no, or something like that.
I think it's fine. You must indicate whether or not every juror is convinced beyond a reasonable doubt, and it goes from there. Okay. So I've changed the word determine for indicate, and I added the words or not after whether, after the word whether. What else?
And then the first sentence of that third paragraph, if with respect to a count, the jury unanimously finds beyond a reasonable doubt.
Yes.
I think it should say each juror finds beyond a reasonable doubt. And then,
Any objection, Mr. Edwards? It's the same thing. I mean, it's saying the jury unanimously finds, but
I prefer it the way that is currently in the instruction. I don't have a strong preference.
and then adding on to that at the end of, so it would read as, my proposal would be that it would read as follows. If with respect to a count, each individual juror finds beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing, and all 12 jurors reach the same outcome, the foreperson shall sign on the designated line in section 1. And what that's really getting at is, again, just communicating to the jury that it's really an individual moral decision versus a group decision.
I'm going to leave it the way it is. I think that point is made very clear throughout the instructions. So that request is denied. What else?
Then I think that there's a typo where it says, and the rest of the jurors shall sign on the other lines in section 2. I think it's still in section 1 that they sign.
And that's
Oh,
correct.
you're right. Thank you. Yep. Thank you for catching that. What else?
And then I think the next sentence, if with respect to account the jury does not so find, it needs to say one or more jurors does not so find.
Mr. Edwards, any objection?
No, Your Honor.
What if I say one or more jurors do not so find?
Yes.
Okay. What else?
I think that's it, but if I can just have a moment to check my notes.
Yes, and then let me know if you have anything on the verdict form.
I think that's it for the,
The people submitted a verdict form that requires all of the jurors to sign if the answer to the question is yes. In other words, if the jury unanimously finds beyond a reasonable doubt that the mitigating factors that exist do not outweigh the aggravating factors proven by the prosecution in phase 1 of the sentencing hearing. The defense didn't submit it like that, but the people did. I'm assuming the people want it this way, Mr. Edwards?
We don't have a strong preference. The reason we suggested that, Your Honor, is that it commits each and every juror individually to have agreed to that verdict.
Ms. Nelson, I'll do it the way you want.
upon further reflection, we're okay with the way that the court's done it, so.
Okay, great. I'll leave it like that.
And then the court, just going back to the bias or
Yes.
prejudice instruction, we would prefer, the court gave us two choices, if I recall correctly.
Yep.
And the choice that we select without waiving our objections is prejudice, so it would read prejudice or bias of any sort against the defendant or the prosecution.
Okay. That's what I'll do. All right, are there any, now I know you tendered instructions, Ms. Nelson, and I went through all your instructions, but I'm gonna ask you to make any record that you wanna make in terms of any concepts that you think should be included in here that I haven't included and that you want me to include.
Your Honor, I think that I covered everything that we need to say.
There was a presumption
Oh, yes, yes.
presumption concept, and I think we've talked about that before.
And we
My-
do maintain that the court give that.
And what the defense was asking the court to do through a tendered instruction is to tell the jury that it should start from a point of believing that there's mitigation and that the mitigation outweighs aggravation, and make it sort of like the presumption of innocence, if you will, that there's a presumption that's favorable to the defendant that the people then have to overcome. And my understanding of the case law is that that's not the way that it works. There is no presumption that applies, and there's no burden of proof that applies. Mr. Edwards, do you have a different position?
No, Your Honor, we agree with the court.
Okay, and for that reason, I did not include that concept in the instructions. Is there anything else that may have been in your tendered instructions that you think we need to talk about, Ms. Nelson?
Can I just have a moment to flip
Yes.
through them quickly, just to make sure I'm not missing anything?
Of course. While she does that, I'll ask you the same question, Mr. Edwards. I know that people tender some instructions. I've specifically addressed the one that you tendered last night. Are there any other instructions you want me to consider, or are there any concepts that you want me to address that you believe were included in your tendered instructions that I haven't talked about, or that I haven't included in my draft and I really should?
No, Your Honor.
Okay.
Your Honor, I think you included this concept that even though Mr. Holmes has presented evidence during this phase of the trial, you're reminded the defendant doesn't have any burden of proof. I think that's in there. I just want to confirm.
It is.
Okay.
It is. Here's what I said about it. It's an instruction that starts with neither party has the burden to prove anything in phase 2 of the sentencing hearing. And then it says the fact that a party may have chosen to present evidence in phase 2 of the sentencing hearing does not change this rule. Similarly, the fact that a party may have chosen not to present evidence in phase 2 of the sentencing hearing does not change this rule. In phase 2 of the sentencing hearing, neither party bears the burden to convince you of anything, including with respect to whether mitigation exists, the weight to be given each aggravating factor and each mitigating factor, and the outcome of the weighing process. So it's that first full paragraph of that instruction.
Further on that, Your Honor,
Okay.
there are two concepts that I wanted to highlight to the court and specifically ask the court to consider including.
Okay.
One is in our defense proposed instruction number 79. And the language, the specific language I wanted to highlight for the court. And again, in making all of these arguments, we are, of course, maintaining our position that our proposed instruction should be given as written. I'm not waiving any of that. But the sentence I wanted to highlight for the court is each individual juror has the authority and power to stop the deliberations at this point and by their decision require imposition of a life sentence. And as support for that, I would just refer the court to the last case that I have cited there in the supporting arguments and authorities, which is People v. Harlan, 109 P. 3rd, 616, Colorado, 2005.
Mr. Edwards?
Your Honor, we object to that. It's already explained in the instructions over and over again. The result of the verdict is a life sentence without.
I agree. I agree. The jury will have no doubt by the end of the instructions that's the case, and so it's unnecessary. What else?
And then the second one I would like to highlight for the court is defense proposed instruction number 84, which states the decisions you are to make concerning the life or death of another person are the most important and serious decisions that you will ever be asked to make. Each of you must fully appreciate your obligation to carefully and fairly consider the choices you have been called upon to make. Each of you must fully appreciate that the life of another person, James Holmes, rests solely in your hands, and rely on the authorities cited in that instruction.
Mr. Edwards?
Your Honor, we object to that. The sentencing phase is really phase 3, where they actually decide whether it's a life sentence or a death sentence. It's not phase 2.
I agree, and in addition, this is obviously clear to these jurors by now in terms of this being important, that someone's life is at stake. They get it. They understand that it's unnecessary, but I think it would be improper at this stage of the proceedings in any event. I read both of the instructions that have just been highlighted by the defense in terms of these tendered instructions 79 and 84, and the case law or the authority cited, I didn't think supported the instructions being given, and for the reasons that I've stated, I continue to believe that they are not unnecessary or appropriate. Anything else, Ms. Nelson?
Time, Your Honor, I'll be submitting an instruction on mitigation in the morning.
So you anticipate one more instruction, right, on mitigation?
I think so. Actually, I think it'll probably be two separate ones, one that's very short and then another one that's longer that fleshes out our theory on mitigation. I think it makes sense to just divide them into two. One would just be a list of the statutory mitigators that we're alleging or asserting, and then the other would be the longer instruction.
So you would have one that says the following are the statutory mitigators that the defense is asserting in this case, and you would have a list of those. And then the next one would be the following are non-statutory mitigators that the defense is alleging exist in this case, something along those lines.
Something like that. I would say in addition to mitigating factors that are defined by the statute that I just listed, the defense is also something.
Okay.
And then an explanation of the rest of the mitigation.
Okay, and I'll probably plan to put those together because I'm going to try to finalize this tonight. So I'm probably going to try to put those two together, one after the other, okay?
Yes, yes. Ooh,
Those two instructions will follow
each
one
other.
another, they'll be
Yes,
together.
yes.
And where in the instructions do you think it makes the most sense to include them? Right before a mitigating factor is not a justification or excuse for the crime? That's the first instruction that talks about mitigation and defines what mitigation is.
The court on that in the morning,
Okay,
Just-
that's fine.
so that I can read it through.
Okay,
Um,
all right.
My instinct is to say maybe after, like immediately after that initial explanation of what mitigation is.
That's fine.
But if I can just reserve the right to change my mind.
The
in
only
the
thing
morning.
is in that instruction that you just referenced, there's a line that talks about the factors, the mitigating factors that were just read to you are examples of mitigation, or the mitigating factors referenced in these instructions are examples of mitigation that you may consider in reaching your phase 2 sentencing verdict. So it might make sense to have them ahead of that, but if you don't mind that and you want to put them after that, that's fine too, so.
Oh, let me think about that for
Okay.
for overnight.
All right, how many pages are you anticipating these last two instructions will be, or do you know?
I don't know, I'd say somewhere between 7 and 10.
7 and 10 pages
Yes.
for the two instructions?
Yes.
Okay. All right, anything else at this time on behalf of the people, Mr. Edwards? Anything else on behalf of the defense?
No, Your Honor, and just so the court knows, the instruction that I'm intending to submit is similar. I don't know if the court has seen what was done in the Owens and the Bueno case, and I think Harlan is another example. But I think those instructions were of similar length, and so my instruction is going to be similar to those.
Okay. All right, we'll be in recess. Thanks, everyone. Thanks for staying late. What I would like to do is to discuss your two last instructions, Ms. Nelson, tomorrow, first thing in the morning at 8:40, and then maybe discuss after that the slides, the PowerPoint presentations for the two parties, okay? And any objections that there may be with respect to those. Is there anything else at this time on behalf of the people? No? Anything else on behalf of the defense?
Your Honor, so we're back at 8:40 in the morning?
8:40, please.
Okay.
Thank you. All right, the court will be in recess. Thank you.